Now see it, person to person, a weekly document for television, as told by the faces and voices of people in the news.
Right. But we're not having a conversation about space aliens here. We're having a conversation about you being there in the moments before his death, and obviously having a significant issue with him. I mean, haven't you been concerned, for instance, that these rumors, even if they're completely fabricated, completely untrue, would harm your career in show business? With time, the rumors will fade away? Well, except that you were with El Duce in the moments before his death. Right, but he wasn't. So Steve, you and Steve and El Duce were all present at this site at this home. Right, but in other words, no, you were the one who was driving the truck or the car that drove him away, right? Well, is that specifically what he was doing? So he went to get a beer. So are you aware, did he go to the Stater Brothers groceries or the liquor store? So, El Duce's dad and people around the world who are concerned with the Kurt Cobain murder are looking at his death as being very strangely coincidental with the timing of that interview with Nick Broomfield. And now you are the person in and around this event as the person who apparently he believed to be the killer of Kurt Cobain. And you were with El Duce in the moments before his death. But you feel that this rumor will just fade away. You're just going to slip away, no one can do anything to you at all.
No, not you. You're just a test. Yeah. We're ready.
It's like, oh my God, what I wasn't really sure.
Oh, man.
I know, I was like,
You guys did realize the second one was correct.
I got the wrong one. I got
Is this an on the record or off the record?
Well, I just wanted to say that, last time you came to our press conference, now it's nice to have you in. You're extremely rude, disruptive. You start raising your voice at other reporters. This press conference is not about Kurt Cobain, and therefore I'm not going to let you back. So maybe some other time, but not on this.
Now see it person to person, a weekly document for television, as told by the faces and voices of people in the news. That is what the program is.
Right. I understand, but I'd rather not have, we let you back, and you were extremely rude and disruptive.
I was not rude. Define rude.
I don't have to
Rude is
define it.
the usage of obscene
I define
terms.
it
Is that what you're calling it?
Not only through my own eyes and ears, but what other reporters have told me. So
They continually interrupted me.
No, you
intentionally.
interrupted them.
No, they interrupted me. I had to say, Neil, give me a break. I'm in the middle of a question here. That's what I had to say. Would you like to review the tape?
no.
Oh, you're not interested in the
No, I'm not
evidence. You're
interested
only
in your
interested
show
in
either.
baseless contentions.
Right. And then
Right
we're
now,
not letting you back.
Satterberg,
This
right?
is not,
Mr.
this is not about
Satterberg.
Kurt Cobain.
Satterberg, is that
This
correct?
is not about
Right
Kurt
now, as we speak, your prosecutors are one floor up in Judge Wartnick's courtroom arguing for an exceptional sentence of 55 years for Steve Sherer, who allegedly has been convicted, of course, of killing his wife in 1990. Now, this is a case in which you presented no physical evidence whatsoever. This is a case where you're relying on expert witnesses to describe domestic violence generally and general patterns of abuse in marriages in order to win a conviction against Mr. Sherer. And this has completely revised people's view of in what way the King County prosecuting attorney is willing to pursue homicide cases. Now, you're saying that has no impact on the Kurt Cobain case whatsoever?
You're welcome to go to the sentencing, and you know, that's a public hearing.
But you have to understand, when a government office holds a press conference and says you are excluded based on our assertion of rudeness, which is a term you're not even willing to define, based on interrupting other reporters who in fact were interrupting me, what you're saying is that if I want access to speak to my prosecuting attorney as a reporter, that I have to sue for the access. Because there are lots of lawsuits all over the country of people suing for access who've been just pejoratively demeaned by press representatives like yourself and then excluded from press conference opportunities. Now, unless you've got some overwhelming evidence of criminal conduct or some disruptive behavior that in some way impaired the King County prosecuting attorney from performing the function of his press conference, you're on very shaky ground.
Very good.
And basically what you're saying is you will exclude us from witnessing or participating in this press conference, so sue us.
I'm saying you're not coming to the press conference, so that's that. I think it's the end of
And
the
on
discussion.
whose authority do you do that? Norm Mailing's authority or your own authority?
The authority of the office. And
The office.
the press conference is not open to you.
And have you cleared this with Norm Mailing?
This is
Well,
a
he is a King
situation-
County prosecuting attorney. If you're taking this extraordinary step and basically saying if you want access, so sue us, it seems to me that you're Satterberg, right?
No, I'm not.
Okay, what's your last name?
Donahoe.
Donahoe, of course. So Donahoe, you're not an attorney, you're a press representative, is that correct?
That's right.
So basically, a press representative is now saying to me that Dan Donahoe, the press representative of Norm Mailing, is saying, based on my own legal wisdom, which is completely unfounded because I'm not an attorney, I've decided to take a so sue us attitude toward Channel 29 and now see it person to person, a weekly document for television, as told by the faces and voices of people in the news.
You got it. Very good. So that's it.
So you're asserting a legal opinion for
I'm
the
not
King
asserting
County
any legal opinion.
prosecuting
I'm just saying
attorney's
you're not-
office,
you're
although you're
coming to
not
the
an
press
attorney.
conference. You're not coming to the press conference, okay? And that's the end of the discussion.
You're sending a guy away for 55 years, Mr. Donahoe.
Press conference is not about that case.
The press conference is not about that case. You're arguing that case right now.
I'm not arguing anything.
This office is
I'm just
arguing
saying
that
you're not
case
coming to our
right
press
now.
conference.
You're trying to send Mr. Sherer away for 55
Well, you can go up to the
years,
sentencing.
and you're saying that the King County prosecuting
You're more than
attorney
welcome to go to
who
the
makes
sentencing.
all of the decisions in this regard, it's not Marilyn Brenneman or anyone else, it's certainly not Dan Donahoe who decides to prosecute Steve Sherer, it's Norm Mailing, the King County prosecuting attorney. Isn't that correct?
Very good. And you can go to the
And
sentencing.
you're limiting
Bye-bye.
press access to the decision maker who's trying to send that man away for 55 years based on an entirely circumstantial case. Donahoe. So there's your government in action, you know. Well, we don't, it's just that these guys, he should spend more time, Donahoe, hanging out with lawyers, which you would think he does, instead of hanging out with cops, which he probably does. Because the fact is that, or maybe it's more accurate to say that the lawyers in King County ought to start acting more like lawyers and less like cops. Because the whole thing about cops is their attitude is based on, don't give me this legal mumbo-jumbo stuff, mister. I'm not interested in your constitutional blah, blah, blah. What I'm interested in is I'm here, I'm the law, and what I says goes. And this is precisely the attitude you get out of Dan Donahoe, press representative for King County prosecuting attorney Norm Mailing. And let's put a fine point on what happened in the last press conference. What happened in the last press conference, in short, is that Norm Mailing, King County prosecuting attorney, came in saying, let me quote Harry Truman. You know, someone who he could practically have gone to grade school with, given his advanced age. Let me quote Harry Truman, when Harry Truman said, if you can't stand the heat,
I can't do business here. Please, 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 I can't do bu
This is a waiting room in a governmental office. This is the waiting area. This is the public area. Right. So what Mailing says is if you can't stand, quote Harry Truman, one of my contemporaries virtually, to quote Harry Truman, if you can't stand the heat, get out of the kitchen. And then, of course, the real point is what we witnessed is that under a few pointed questions from yours truly, from Now See It Person to Person, Now See It Person to Person, a weekly document for television as told by the faces and voices of people in the news, what we find is that only a few of our questions regarding why they decided not to prosecute the king of homicide, Mr. Homicide, Donald Cameron, Sergeant Detective of the Seattle Police Department, resulted in, of course, Mr. Mailing running like a frightened little girl from his own press conference. And we could virtually just, we could literally just end it there with a full stop, couldn't we? You know? Which is really precisely what Mailing ought to do. I mean, this idea of, you know, keeping this guy on eon after eon because of his, you know, long-standing ambition to fulfill his destiny as the next guy in line to be governor, although, of course, he's a Republican, and who are the Republicans running this time? The Republicans are running hot talk, hate talk, talk show host John Carlson. And I would call the station hot talk, hate talk. As far as Carlson engaging in hate talk, I don't really know enough about his position. Oh, say Mr. Sandberg. They know Sandberg? So, in other words, right, I don't know enough about Carlson's career as a hate talk, hot talker to know whether he really deserves the opprobrium hate talk, although that goes along with the KBI station in which he was formerly employed. In any case, geez, I got guys in suits swarming all around us here. I wonder how many of these esteemed members of the law are packing Glocks. In any case, so Mailing is such a has-been, he's not even doing his usual half-hearted effort for the gubernatorial spot on the Republican ticket. He's given it over to a hot talker, you know, a guy who started out as one of those many conservatives in his college years by taking money from conservative think tanks to start his own little college newspaper, and then, of course, it all had a highly so-called conservative outlook, meaning, well, I haven't seen his literature, so let's just stay away from that. But some of those so-called conservative rags around the country being published on college papers really lean toward the race baiting, and I can't say that that was necessarily the case with him, but that was a sort of general pattern in many of them. Anyway, he's just a hot talk loudmouth, and Mailing isn't even taking on Gary Locke, you know? I mean, how tough would that be? So instead, he's decided just to cling tightly with gnarly knobbed digits to the post of King County Prosecuting Attorney until such time that his life has expired, presumably. Seems to think that this elected office is a sort of a Supreme Court appointment, a U.S. Supreme Court appointment. But you saw the objectionable bit there, didn't you? You know? Exclusion, this Donahoe guy is excluding me, and based on rudeness, to reporters. I mean, he didn't even have the nerve to say that it's on orders from the prosecuting attorney. He didn't even have the nerve to say that it has anything to do with the impairment of the King County prosecuting attorney to put across his program effectively to the news bite media. And what I mean by that is, let's face it, what do they really all hate about our program? It's not even the opinion. It's not even the pointed questioning, really. You know, I mean, obviously those are factors. But the thing that really sticks in their craw more than anything else is that it's presented at length and without commercial interruption. You know? I mean, the news of the day, from as dictated by the King County Prosecuting Attorney's Office or anyone else, in between spots for Geritol and Viagra and Ducolax, well, that's something that, you know, most people really aren't going to pay too much attention to. Nobody's going to get too excited about. But the weekly documentary format is what makes their skin crawl. My God, if people watched King County Prosecuting Attorney Norm Mailing speak for more than 2 minutes at a time, they're going to start to detect that senility factor. And that could be bad for business. After all, we're sending guys to the electric chair. We're sending guys away for 55 years based on 10-year-old cases that lay dormant in the files of the Redmond Police Department for 6 years, only to be revived and then aggressively investigated and advocated by this office. Now, I'm not saying that Sherer is innocent. I really have no idea, but based on the press accounts and the sort of mumbo-jumbo psychological nonsense that I've heard even this morning, my God, they're going to send this guy away for double nickels for killing his wife with no physical evidence? Well, I do think that certain cases should be brought on that basis, purely on circumstantial evidence, you know. Certainly, you shouldn't be allowed to get away with murder just because you've done an effective job in disposing of the body. However, you know, let's just draw the parallel to the OJ case. Well, of course, OJ looks guilty as hell. But as for anyone who voted for acquittal, you know, you have to acknowledge that there was a basis for that. After all, OJ was prosecuted by a lame-brained district attorney's office. Therefore, you know, how much responsibility is supposed to lay on the shoulders of the jurors to overcompensate for the fact that, you know, compelling evidence simply was not presented effectively in the OJ trial. So what I'm saying is, sure, maybe Steve Sherer is guilty, and maybe a very compelling case based on circumstantial evidence could be put together. But based on everything I've seen out of this office, it's far more likely that they did a bit of monkeying about with jury selection and that Scherer's attorneys were not attentive to that aspect, that very persuasive aspect of this whole case, perhaps wanting, well, we won't say that they're in line, desiring the appeals fees as well, but because that is a bit slanderous, I suppose, based on not too much evidence, but you know, the fact is that these things go down in jury selection more so than anywhere else in the trial, and that's the kind of thing that I would say they do very effectively in this courthouse. You know, engineering jury selection. Yep. That's how it's done. So when they're talking about restricting the access of the leading political reporter in Seattle, Washington, to the press conference of the King County prosecuting attorney as they are sentencing Mr. Sherer, you know, one floor above us, to what the prosecutor wants is an exceptional sentence of 55 years. You know, something more going on here than just an abhorrence of rudeness or some sort of utmost respect for Neil Karlinski or Brian Johnson to jump in with interruptions. while I'm asking extremely significant questions, the very questions that were on the minds of the other reporters in that press conference about Don Cameron and Sonny Davis, that none of them had the nerve/intelligence to ask. You know, they all benefited from the fact of my questioning. It certainly has been the case that my questioning has led to their sound bites upon occasion, so don't kid me about rudeness or anything else. No. I haven't been at this long and this successfully based on just on a whim going off with some ill-founded desire to be confrontational at all costs. Nevertheless, let's just underline, if you can't take the heat, get out of the kitchen. And if you can't take the heat that comes from a few pointed questions from an experienced reporter, an aging and experienced reporter, then perhaps your term in office is just too aged indeed. Time to get out of the kitchen.
That you want, but nothing is ever as black and white as being portrayed. You saw home videotapes, you've read letters from Jamie Sherer. This is not somebody who was being tortured daily in a relationship. I'm sorry. There's evidence on one occasion that he did violently assault her and pull her hair out. But that is no different. This is no different from any other domestic violence homicide. And that's the testimony of an expert. And the legislature did not, at the time, authorize that to be a grounds for 660 months. And if they want to do that, they can. But they didn't.
Excuse me.
I was found guilty and convicted of a crime I did not commit. There's been a lot of things that are said in this trial that were half-truths, twisted truths. Some were blatant lies. One thing that did come out that in this truth that was the truth, and that Jamie was a good person, and that she loved my son very much, and that was her entire life. I understand that the Hayden family has a loss, and I sympathize with them. I also sympathize with my family with their loss, including of Jamie. Her friends, Jamie was loved by them. She loved them in return. I've made a lot of mistakes in my life, a lot of errors, a lot of bad judgment. I've led maybe a life that wasn't correct. But I'm not a murderer. I did not murder my wife, and I had nothing to do with it. Thank you.
First of all, I think there are a few things that they're commenting on that relate to the sentencing process that have been raised by members of Mr. Scherer's family and their friends in the correspondence to the court. First of all, the concept in our law that circumstantial evidence can be as valuable and compelling as direct and physical evidence, I think is certainly difficult for many people to, including lawyers, to grasp and accept. And I know from my own experience practicing law for many years before assuming the bench That was also always a troublesome area. I know just from comments from friends of mine following the verdict, who are lawyers practicing in the civil field, that it was difficult to grasp and accept. The fact that a person can be found guilty based solely on circumstantial evidence, I think, in the minds of many, really seems to defy our basic instinct in relation to the state's burden of proving guilt beyond a reasonable doubt. Because of that, I think it's certainly understandable that Mr. Scherer's family and family and friends would feel that the evidence was not sufficient to justify the verdict in this case. However, the law is clear, and the jury was so instructed, that circumstantial evidence is not necessarily less nor more valuable than direct evidence. In this case, one in which there was no direct or physical evidence of death, cause or method of death, or of a crime scene, the circumstantial evidence that Jamie Sherer did die on September 30, 1990, and that the defendant caused her death with premeditated intent was substantial and compelling. Next, I want to take a moment to talk about the jury deliberations and verdict in relation to concerns expressed by members of the Sherer family and friends. The fact that the jury deliberated for 5 full days before returning a verdict, I believe in this case is testament to the time and care taken to work through the evidence and issues in this case. There has not been any evidence presented to the court that would indicate that the trial or that the deliberation process was impacted in any way by the attention given this case during the trial by the news media, or that the verdict was based on emotion, passion, or prejudice. There is absolutely no evidence that the jury violated its oath and the directives of the court to not read, view, or listen to news reports, or to permit anyone in their presence to read or discuss news reports with them. Given what I have just said about the law of circumstantial evidence and the instinctive problems the concept presents for people, it would not be unreasonable to assume the jury might have taken a day or more just coming to grips with the realization that circumstantial evidence alone can provide the basis for a finding of guilty beyond a reasonable doubt, before even starting to take the time to carefully review the evidence to determine if, in fact, the circumstantial evidence in this case proved guilt beyond a reasonable doubt. The evidence in this regard was overwhelming, and the jury was more than justified in finding the defendant guilty of first-degree and second-degree murder. Now it's my duty to accept the verdict and to determine the proper sentence for a person who has committed murder in the first degree. I believe that there are at least 6 bases for an exceptional sentence in this case, one of which wasn't even mentioned by the state, and I believe that each, standing by itself, much less in conjunction with each other, is substantial and compelling in justifying an exceptional sentence. The Halloween card, Exhibit 11, but the fact that he signed it, "Love You Forever, Dad and Mom," seems to be extremely cruel. But he could be released. I'm satisfied that 720 months or 60 years is the appropriate exceptional sentence in this case, and I so order it. In addition, Mr. Sherer, you will be prohibited from having any contact with anyone who testified against you in this case, direct or indirect, for the maximum term of which you can be sentenced. You'll be required to pay the $500 victim penalty assessment.
It's Emily. Can you get on the 11 that the judge sentenced Sherer to 60 years, more than the prosecution was asking for?
You'll be required find the fact that Mr. Sherer, I believe the evidence is clear that he was one that initiated it. Extremely reprehensible and cruel. Introduce and foist upon his wife the type of sexual activities that they engaged in, creating the environment for the very thing that he threatened he would kill her for if she ever did it. It's like a self-prophecy.
Down in front.
Is this justice?
Oh, that was fun. Emily?
Ouch, that's gotta hurt.
It's not. Oh, yeah, it is.
60 years.
Sorry.
Ouch.
Okay, I will. All right. Someone would like to look at another case?
Yes.
Ellen, you were talking about the fact that the judge went for 60 years instead of the 55 you've been asking for. How's that hit you?
I just think it shows that he paid extremely careful attention. I knew that throughout the trial, and it's gratifying to know that he found the behavior that we found in this case as extreme and distressing as we did. He went beyond 5 years beyond what we were asking for. I think that's perfectly permissible. Not only permissible, it's perfectly supported by the evidence in this case. I don't have any problem with that. We're gratified, we're pleased. And he took quite a while to explain the bases for his judgment, and they were well-founded in both the facts of this case and the law.
The family in their letters, Stephen Sherer's family, all said they couldn't understand how he could be found guilty. When the judge informed them and was very careful to inform them that he found the evidence overwhelming, why do you think he was doing that? What message was he trying to send?
I think it's an important message to send to the public that you don't get away with what could be considered a perfect crime. The disposal of a body or the failure to provide closure for the victim's family isn't going to be sufficient to protect you. And the law is very clear on that in Washington State and in fact throughout the country, that the mere absence of a body does not preclude prosecution and conviction of murder when the other evidence is, as the judge indicated, overwhelming. And that's what he was saying. He was saying it to the family of the defendant, who was seeing things obviously in a way they needed to see things. But more importantly, he's saying that to everyone else in the community. If you kill someone, simply disposing of the body won't be enough to protect you from a prosecution.
Well, Marilyn, I'm sure that legal scholars throughout the ages would be very interested in your opinion on when it is that the King County Prosecutor's Office should bring a case largely based on circumstantial evidence, which obviously this case was.
We bring a case when the evidence is compelling and overwhelming, as characterized by the judge in this case. And that's what the jury found, and that's what was presented, and that's what the judge found.
And do you think that it's ever been the case that the King County Prosecuting Attorney's Office has failed to bring a case of first-degree murder with more compelling evidence than this?
I can't speak to that. I can only speak to the cases I'm familiar with. I have another matter now, so thanks.
Hello.
Hi.
Well, congratulations.
Thanks. Do you want to go downstairs?
I would love to go downstairs.
Well, Marilyn, just one more thing. When is it that the prosecuting attorneys invoked this process of bringing about an inquiry judge, more or less our grand jury system here in King County in a first-degree murder case?
That's a case-by-case decision.
But I mean, just generally, how would you describe the standards?
when it's needed.
Well, for instance, if there's someone strutting around Riverside, California saying, I murdered Kurt Cobain, and this person is known to have been in the presence of a person who, for instance, died by an impact of locomotive within minutes.
I have no familiarity with anything that you're talking about except from you. I don't
If
know.
there's a person who's a sort of known hitman strutting around saying, I murdered Kurt Cobain, is that the sort of thing that might invoke the prosecutor's office?
Would you open the door, please?
The prosecutor's office to opening one of these judges' inquests.
I can't speak to anything that you've spoken to because I don't have any idea about what you're talking about.
Well, beyond when needed, what are the standards for bringing
I'm
it
not
out?
going to talk about specific matters that I have no knowledge of.
No, but just generally, what are the standards for bringing about the judge's
I don't have
inquiry?
any idea what you're talking
It's
about.
the grand jury system, the judge's inquiry.
I understand about the inquiry judge and the
But beyond
standards on...
as needed, what are the standards?
I'm asking you to leave now. Got another meeting. Thank you.
Hello, we're here.
They said on 5. Go down to 5.
Well, if they're going to behave like bandits, you got to chase them down like bandits, right? We do it as needed. Murder cases, we do them as we need them. As needed. Marilyn's been spending too much time in the cookbooks and not enough time in the law books. We bring about prosecutions seasoned as needed. We decided we needed a little bit more seasoning this year, so we decided to spice it up with a 10-year-old murder mystery. I'm not saying he's not guilty. I'm just saying, who knows? Who could know?
He's a very good jurist.
Clean though with
He's just a really good
Yeah, I think he took the time, and that showed. So.
And so he cares about everybody, including the defendants.
Hi, Cheryl. I'll be right back. You can't follow me there.
Marilyn, but quite seriously, what would you say in terms of defining when these judicial inquiries begin?
They're on a case-by-case basis.
Right. But for instance, if there's someone who is proclaiming his guilt in Riverside, California, I murdered Kurt Cobain. I murdered Kurt Cobain.
I'm not going to speak hypothetically
I
about
accepted
facts. I don't-
$50,000 to whack Kurt Cobain. Would that be enough to bring about a judicial inquiry?
Isn't that what the guy says? Isn't that what his mass-produced record jacket says? I took 50 grand to whack Kurt Cobain, right? Well, there's one that's career-making for you, Marilyn. Yo, Marilyn, there's one that's career-making for you, babe. There's always going to be people with doubts about the Steve Sherer thing. Sure, he's a kind of a ratty guy, and sure, Judge Wortnick blanketly excused in some highly Catholic manner all of his wife's sexual indiscretions by indicating, as an afterthought, even after handing down the sentence, he exonerated her of all sexual blame and all sexual misdeeds or sins, if you will, on a basis of her husband obviously coerced her into these, as if Judge Wortnick would have that much insight as to what went on in the genital functions of the Sherer marriage. So if Marilyn's looking to base her reputation or some further arc of her career on this great success, it's true that it's a unique achievement, but as to whether it's just is always going to be a little bit tricky to define, isn't it? that is, who knows if he did it. Just to put the final touch on all of this, every newspaper article that's ever published on this thing, and of course they overlook this on the TV, but in the news the print media, they tend to emphasize the two main components of this case. A, absolutely no physical evidence whatsoever. B, she was shacking up in a motel room with a cocaine dealer from Idaho the night before she died, which means, I don't know. I mean, that seems like reasonable doubt right there, right? Obviously, I didn't attend the trial, but it's difficult to see how that doesn't introduce a certain element of doubt now 10 years later. And of course, that's what the defense argued, but again, something in that jury pool made it difficult to win over even one juror to the defendant's side. So if Marilyn really wants to hit the national spotlight in a really groovy way, what she really ought to do is push for an investigation on this Cobain thing over the objections of press aide Dan Donahoe and his obviously gung-ho desires to restrict the access of the press to the real information on the murder cases of the day. Marilyn ought to just jump on it. Just go for it, babe. You got a Satanist. He's not really in L.A. He's in the seamy little town of Riverside, You got a Satanist who may have pushed El Duce under that train or put his body on the tracks. You got a Satanist who's going around saying, I took 50 grand to murder Kurt Cobain. You got Dr. Gelb, the noted polygraph expert, saying that yes, 50 grand was the amount proposed to Eldon Hoke El Duce. If Marilyn wasn't so busy running back and forth to these presumably non-existent meetings of any urgency anyway, what she'd have is a world-class first-degree murder case signed, sealed, and delivered. And if you want premeditation, if Marilyn and Judge Wartnick are really gung-ho about going after those murderers with premeditation, what do you call making the proposal for the sum of $50,000 3 months before the guy dies? That's long-term premeditation. You can't get any more long-term or premeditated than that, can you? I mean, any more long-term and you'd start to doubt whether it was part of the same plan. $50,000 to whack Kurt Cobain. Established as a matter of fact, so would assert Dr. Edward Gelb. Edward I. Gelb, in private practice as a polygraph examiner in Los Angeles for 32 years. Past president of the American Polygraph Association. Signed, sealed, and delivered. There it is, figuratively speaking. Come and get it. Of course, we know how crafty these slots are in the door of the King County Prosecuting Attorney's Office. Drop something in, they'll deny they ever got it. But in this case, it's on TV. Look, here it is. The perfect solution to the perfect murder, signed, sealed, and delivered. How can you turn that down? Marilyn, Norm, et al.
Just kidding. Oh my God. I think you need a vacation.
Yeah, I won't have that, yes, I know. Be right there. So you take them right down. That was to
So you were certain that you had arrived at the scene of the automobile prior to the police ever being there?
I'm certain of that, yes.
So was that the primary factor in convincing you that something was wrong with this?
Well, that and his change in behavior. Normally when they fought, like his mom said, he'd be on the phone every 5 minutes. Where is she? I want to talk to her. Where is she? I want to talk to her. His normal behavior would have been to hunt for her forever. He put on a show of looking for her. I went with him for one day. He only called her mother once that day, maybe twice. He showed up at my house with a shovel in the back of his truck. There was just a lot of things and little tiny pieces to a big puzzle. Eventually it came together.
Did you ever reach a conclusion on your own that shovel was terribly meaningful, that he did in fact use the shovel for...
No, I was trying to stay on his side the whole time. Until the very trial, I was trying to believe that he was innocent.
Oh, over the last 10 years?
Yes. He had me believing he was being persecuted, that he'd lost his wife, he'd lost his son, he'd lost his job. He'd been run out of the state. Now I no longer believe any of that's true.
Well, was there a single element that sort of turned you against his point of view?
1 second. No, there's no single element. It's just a lot of pieces to a big puzzle, and it creates a picture when you look at it all. I'm sorry, but I have to run.
Sure.
Here's Eldon Hoke's examination. And here, as an example, is the reaction to the comparison question compared to the relevant question. Did Courtney Love ask you to kill Kurt Cobain? He said yes, and you see there's less reaction here than to the comparison question, indicating that he's being truthful on this question, and he's more uncomfortable with the comparison question. You see that big reaction here, here, and here compared to this, this, and this?
Is there a specific form of the comparison question that you always go to, or?
It's always different based on the background of the person. That's what you're developing in this pre-test interview, which would be the right kind of comparison questions.
But is it often as simple as, is your name
No.
Eleanor Roosevelt?
No. No, it's pretty much sophisticated, much more sophisticated than that.
But in fact, is it the case that you ask someone a baseline question or a comparison question which is guaranteed to...
Here's a comparison question. Here's the relevant question. Baseline arousal, more reactivity than this, more reactivity than this, more reaction on the comparison question, therefore he's being called truthful on the relevant question.